everyone, and welcome to yet another episode of IPTSC podcasts. Today, we have Mr. Anand Choubey with us. Mr. Anand Choubey is a partner mechanical engineering, design, patent, and design valuation, and also a member of management committee at K&S Partners. He is a leading patent expert with cross-industry expertise and advises corporate clients, multinationals, MNCs, startups, and universities across domain areas from mechanical to biomedical engineering. Mr. Anand holds a degree in law, a degree in mechanical engineering, and is a master's in industrial tribology and maintenance engineering from IIT Delhi. He is also a registered patent agent. Mr. Anand has over 19 years of work experience with 2 global awards and 6 publications under his name. We are delighted to have you, Mr. Anand, yet another time, and thank you for joining us.
Thank you for having me.
Okay, so today we would be discussing more on the patents and the patents processes. So now, since you're an expert in the field of automotive systems and auto industry, which is a highly competitive industry, what strategies would you recommend to protect the IP in such a competitive area?
Once again, thank you very much for having me here. It's a pleasure. So automotive industry and automotive component industry is going through a very transformative phase. As we all can see, there is a shift in focus towards electric vehicles, battery-related technologies, a lot of integration of software in the automotive systems.
Right.
So continuous improvement, continuous innovation can help dealing with or adapting to these technological changes. It's also important having a robust IP strategies in place so that timely identification of IPs can be done, and also the IPs can be protected in a timely manner.
Right.
Some of the IP strategies that comes to my mind is having a process in place which can help you identify the types of IP.
Okay.
As in automotive industry, it is possible that one product may have multiple intellectual properties in it.
Okay.
One product may have a patent, a trademark, a design, or copyright.
Okay.
So it's important that we timely identify the intellectual property and timely protect it.
Okay.
Second is, it's a very common scenario where in the automotive industry where the product is developed through or involve global complex supply chain, which means that parts or components may be sourced from one jurisdiction.
Okay.
And these parts are assembled and manufactured in another jurisdiction.
Right.
And commercialization and the selling of the product is happening in a different jurisdiction.
Okay.
So it's important that IP is protected in each of these jurisdictions.
Okay.
Because some of the IP such as patent and designs are territorial in nature, which means that a patent and design which is granted or registered in one country or jurisdiction is enforceable in that jurisdiction only.
Okay.
So wherever you want to protect the IP or patent or design, you need to file the patent application or design application in that jurisdiction.
Right.
The another, something which is very important to put in an IP strategy is that having an IP diligence, which may include conducting a landscape study or freedom to operate study. Landscape study can give a useful insight about the areas which are not yet explored. Right,
Okay.
it can give insights to organizations to direct their R&D efforts.
Okay.
And freedom to operate can help you identify if there are any third-party patent which can be a roadblock for your product.
Right.
So you can check if your product is not infringing any third-party's patent.
Right. Okay. So, as you mentioned that the product could have different IPs involved, right? Your patents and designs and copyrights. Most of us are aware that patents and designs are the IPs involved in an automotive industry. Could you throw some light as to how copyright gets into the picture?
Yeah, as I mentioned that there are a lot of software integration is happening in the automotive industry as well, and automotive systems. So computer program or source code can be a subject matter of copyright.
Okay.
So if there is some source code which is developed and you want to protect it, copyright can be the IP
which is involved
for
Okay.
protection. Yeah.
And so for a particular product, all the IPs have to be filed simultaneously. How is the process? Like you're filing for a patent, you're filing for a copyright. It has to go hand in hand, or it could be.
So yeah, I mean, once you have multiple IPs in it, so when it comes to patent and designs, so you can file a patent and you can also file a design. You can file simultaneously, right, or at different timings as well.
Okay.
But we have to has to be taken that if you file a patent, then or a design as well, then one should not become the prior art of other because
Okay.
of publication.
Right.
So normally the design gets published in a very faster way, it gets registered faster. So we always advise that you file the patent and design
Patent first.
together, or
Okay.
file the patent first,
Right.
and then
Okay.
you file the design. So at that time you are also clear as to what is covered in the patent, so your product is finalized and you can file the designs on that. Yeah.
Okay. Right. And yeah, so as you said, again, for different jurisdictions, it has to be how is the process? How do you go about the different jurisdictions if you have to file it?
Yeah. Okay. So for filing a patent application
Yes.
in multiple jurisdictions, so there are some timelines which are prescribed. Uh, Such as when you file the Indian application, Indian patent applications, you can file foreign patent applications claiming priority from this Indian applications within 12 months of time.
Okay.
Alternatively, you can file a PCT application, which we call it as international application, that will give you additional time for extending your patent application into foreign jurisdiction.
Okay.
So you get about 30 months of time from the first filing to file your foreign applications.
Right.
So if you are directly going under Paris Convention, you have 12 months of time to file your foreign patent applications claiming priority from the Indian patent application. But if you are taking a PCT route,
Okay.
you can extend your foreign applications within 30 months of time from the first Indian application. So these are the timelines that needs to be kept in mind, taken care of when you are extending your patent application outside India.
Okay. Right. Coming up to the inventors and innovators, what do you think are the common mistakes that they do while applying for a patent, and how do you suggest how could they resolve it?
Yeah. So one mistake that we often come across is that the disclosure of the invention before filing of the patent application.
Okay.
As any publication or disclosure of the invention before filing the patent application can destroy the novelty of the invention which is covered or being disclosed in the patent application. So it's important that any disclosure done after the filing of the application, even the publication of the research paper,
Right.
etc., should be done after the filing of the patent application, because sometimes the subject matter that you're disclosing in the research paper can be a prior art for the patent application that you're subsequently filing.
Okay.
Another area which require more awareness is about the what is invention. Often inventors think that the invention is something which should be a breakthrough invention, whereas innovation can be anything which is an improvement over what existed earlier. So the patentability criteria needs to be checked, or the innovation needs to be analyzed if it fulfills the patentability criteria, and if it fulfills the criteria of novelty, inventiveness over what has been already known, it can be covered in the patent.
So how can inventors actually find out if they fall under the patentability criteria? Like prior art search, I think,
Yes,
is one
absolutely.
of them. Yeah?
Prior art search is basically conducting a patent search,
Right.
Because patent gives while prior art can come from both patent and non-patent literature. So one can conduct prior art search to see what is already known, and they are not reinventing the wheel, and they can look at the prior art and see how their product is novel, or whatever they are proposing as a solution to an existing problem is something novel and inventive. So yes, prior art search can help a lot to identify. It can also help when you are drafting the patent application. It can help you to clearly identify what are the novel features. So when the application goes for examination, you have the sufficient material available in the specification which can help you making the distinction during the examination report from these prior arts.
Okay. So do you suggest that the inventor could do it himself, or is there any specific professional help that that would be better to do even the prior art search and even for filing a patent or something?
Yeah, so while inventors can do
AMP.
themselves, but always professional help is useful because because of the knowledge and the experience can help you identify and the relevant information that needs to be captured in this application.
Okay.
Also, in a particular format, it has to be written, keeping all the technical as well as the legal
Legal
requirements in
aspects.
mind.
Okay.
While inventors can provide the technical input about the invention, they can explain the invention, but from the legal side and the procedural side, the professional can help, can be very useful for having a proper patent application drafted, and also taking it from filing till the prosecution.
Grant.
Yeah, and to the grant of the patent application. Yes.
Okay. So, what is the usual timeline for getting a patent approval, and what could be the factors that could actually delay the process?
Uh, well, so it is difficult to predict the exact timeline from filing till grant because there are multiple factors which, because of which this timeline may vary from case to case basis. But based on the experience, it may take somewhere about 3 years to 3.5 years from filing till grant.
Till grant,
Okay.
okay.
This is in case of a normal route or normal request for examination if the applicant has submitted. But if the applicant has submitted expedited examination request, then it may take about 1 year to 1.5 year time from filing till grant. The factors which affect the timeline, I would say the request for examination is a very important formality, and you get about 31 months. Not about it's you get 31 months of time from the priority date to file the request for examination. So this is the maximum time available,
Right.
and it's an important formality which one has to do to activate the prosecution of the application. Patent office will examine the application
Only when they
only when the
receive
request for examination is filed. Now, if you see that if somebody files a request for examination early, right, its application will be taken up for examination early, as compared to an application where the request for examination is
Has not been
later
filed or
or
later.
closer to the 31-month timeline which is given.
Okay.
So, timely filing the request for examination can help you to put your application in queue for the examination, and that can affect the overall timeline from filing till grant.
Yeah. So, sorry to interject, but like you said, the 31-month timeline, right?
Yeah.
So, if someone does not file the examination request, right? What happens then?
So it's a
Within that
mandatory
31
requirement. If you don't file it, the application lapses.
So, you have to
Yeah,
again.
you cannot retrieve it.
Okay.
Once, if you do not file request for examination, the patent application will get lapsed, and you
Okay.
cannot retrieve that application.
You cannot retrieve.
Yes.
Okay, fine. Coming to the next question, like you've been managing and providing diligence and analysis for various international and Indian clients. So, is there any particular challenge that you've faced, especially while dealing with international patents?
So there are few administrative challenges that may come across, such as when you file the application in multiple jurisdiction. So each jurisdiction will have their own formal requirements to be complied with, and these formal requirements will have different timelines within which you have to comply with these formalities, etc. So this may give some kind of administrative challenge or burden for the applicant. The second is each country will have their own independent examination. So they will issue the examination report, which will at different stages and with different timelines. And
Right.
Filing a response to the examination report at different timelines will put some administrative challenge. In addition, since the examinations are independent, so it is possible that you will receive different types of objections from different jurisdiction. Some objections may be common, but some objections may be new or different from the other jurisdiction.
Right.
So here,
So you
the
have to deal
response
with all of
strategy,
those, yeah,
you have to deal with all of
separately.
those, and response strategy, claim amendment, etc., needs to be synced with each other, so that there is no contradiction between what you are stating in the response in one jurisdiction
Yes.
as compared to what you're stating in your response in the other jurisdiction. Yeah.
Right. Okay. What are some of the most common misconceptions that you've come across that you think people have regarding patents or patent processes?
As I said, there are few areas which require more awareness about that the invention needs to be breakthrough. It need not be a breakthrough invention. It can be an improvement. over the what is already known can also be a patentable subject matter. Simplicity is not a bar for patentability, as we always say. And in addition to that, having a patent means it's an freedom to operate, whereas it is possible that your product is patented, but there are certain features of the product may still fall in third party's patent. So freedom to operate study or search can help you that your product has a freedom to operate and it is not infringing any other third party's patent. The another area that require more awareness about the software or computer related inventions. So these inventions are also patentable, provided they fulfill the criteria which is laid out in the examination guidelines for computer related inventions. Yeah.
Okay, right, great. So, for the budding practitioners and students to stay updated with the changes in the patent law and various emerging and intersecting fields, how do you recommend that? How could they balance between the technical and the legal aspects of the job?
So, so as a patent practitioner, a patent attorney, I mean, we need to have strong fundamental about the science and engineering so that we can understand the technology from the inventors better. When we work on a drafting of a patent application, so we conduct interview with inventors. We ask questions to develop a thorough understanding about the invention. What is the problem they have addressed in their invention? What is the proposed solution? And what are the features of the invention which provides or implement those solutions? So this detailed discussion or deliberation with the inventors is done before drafting of the application so that we have a thorough understanding developed about the invention. And then when we draft the patent application, we have to keep it in mind both the technical aspects of the invention and describing them in detail, as well as the requirements under the patent law in terms of the requirements of sufficiency, enablement, unity of invention, etc. When we draft the patent application. So since it's a techno-legal document, so invention needs to be described in detail to ensure that essential novel inventive features are described and also claimed in the patent application.
So it's the technical aspects which you have to take into consideration first, followed by the legal.
Yes, because both the things are looked at and considered when drafting the patent application. Also, you have to anticipate several objections that might come during the examination stage, and these objections are addressed during the drafting of the patent applications. Then you will have a relatively simpler prosecution when the application goes for examination.
Right.
So, for example, usage of certain terms, there is enough clarity. There is no indefiniteness when you are drafting the claims. Any term that is being coined or defined, that they are properly described and defined in the patent application. Some of these and also the whatever subject matter that you are claiming is also supported by the description and specification. So some of these elements that we keep it in mind, that okay, these are the objections that might come during the examination stage, and we based on the experience, because we have handled several examination reports, so based on that experience we try to address them during the drafting of the patent application. Yeah.
Okay. Now, what would be your advice to students who are wanting to pursue a career as in patent law specifically? And what is the educational background or the skill set that they would require?
So for students who wants to pursue the career in patent law, they can consider taking internships, with organization who are practicing in this area. Internship can give them an opportunity to interact with the patent attorneys or patent professionals more closely, so that they develop better understanding about the patent law and IP practice as a career avenue or career path. In terms of the skill sets, I would say, as I said, that for the patent, technical subjects is important. So strong fundamentals about the technology and engineering subjects comes as very useful.
And it's a must actually, right?
It's a must. It's must. Yes. Other than that, on the softer side, better communication skill, both written as well as verbal communication skill. Also, strong analytical abilities can help them, become a better patent attorney or better patent professionals.
Okay.
In terms of qualification, you asked. For practicing as patent agent before the patent office, you have to clear the patent agent exam.
So, what is the process for getting to clearing the patent agent exam?
Patent agent exam is conducted every year by the patent
Yes,
office.
every year.
So you have to apply for the exam, and the eligibility requirement is that you need to have a degree in science and technology, and there is a written test and the Viva OC which is conducted.
Right.
Once you clear that, you can be registered as a patent agent.
Patent agent. Okay. So you mentioned about the internships. Now, could you throw some light onto a specific internship process that K&S Partners would be having? Because, of course, our IPTSC students and the students who are watching us, they would be interested if there's any specific program that you have for the students.
Yeah. So we have short-term internship as well as long-term internship. So mostly the students who are pursuing law undertake short-term internship. Short-term internship is about 1 month to 2 months time.
Okay.
And long-term internship we offer for students who are pursuing the engineering courses.
Right.
And provided their engineering course in their last semester have this option of internship available. So for that we coordinate with the training and placement officer of the universities and institutes, and then offer these internship.
Okay.
And we conduct a written test and interview for hiring interns for this long-term internship.
Right.
Yeah.
So great. So I think we've had a very good discussions covering patents and the patent processes, and of course the internship opportunities. So thank you, Mr. Anand, for being with us again. And we would love to have you for maybe another round of discussions and another podcast episode.
Thank you very much. It's a pleasure. Thank you.